Hello everyone, welcome to the Cultural and Educational Rights, Article 29, Protection of Interests of Minorities. Clause 1. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. Clause 2. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. And Article 30, with title Right of Minorities to Establish and Administer Educational Institutions. Clause 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Clause 1A. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority referred to in clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. Clause 2, the state shall not, in granting aid to educational institutions discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. So about the evolution of article and right under article 30 is not absolute. Let us be clear on that article 30 grants the following rights to minorities, whether religious or linguistic. A. All religious or linguistic minorities shall have the right to establish and administer educational institutions of their choice. Yes. B. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. C. In granting aid, the state shall not discriminate against any educational institution managed by a minority on the basis of only religion or language. Now, about the distinction between Article 29, 1, Clause 1, 29, Clause 1, and Article 30, Clause 1. The point may be written as Article 29, Clause 1 confers rights on all sections of society, whereas Article 30, Clause 1 confers right only on minority based on language or religion. Article 29, Clause 1 deals with three subjects, that is language. We can read about Article 21, 29, Clause 1. Article 29, Clause 1 deals with three subjects, that is language, script, and culture. Article 30, Clause 1 deals with educational institution. Article 29, Clause 1 provides right to conserve language, script, or culture, whereas Article 30, Clause 1 provides right to minorities to establish and administer educational institutions. Right and about Article right under 30 is not absolute. It was said in Re Kerala Education Bill AIR 1958. The Supreme Court held that fundamental right given to all minorities under Article 30, Clause 1 to establish and administer educational institutions of their choice does not militate against the claim of a state to insist that in granting aid the state may prescribe reasonable restrictions to ensure the excellence of the institutions. However, it should not take away the rights of minorities guaranteed by Article 30, Clause 1, and thus the right enshrined under Article 30, Clause 1 is not an absolute one. In St. Xavier's College versus State of Gujarat, AIR 1974, the validity of certain sections of Gujarat University Act was challenged, which provided for administration of college in effect to government and the university through which the college is affiliated. The Supreme Court held that these provisions abridged the right of the minority to administer the educational institutions and also stated that right to administer includes the right to conduct and manage the affairs of institution. In St. Stephen's College versus University of Delhi, AIR 1992, uh, this is the college in my campus itself, in St. Stephen's College, University of Delhi. The Supreme Court observed in this case that the right to select students for admission is an important facet of administration and thus is inherent in the right under Article 30, Clause 1. It was further held by the Supreme Court that minority aided educational institutions may preserve 50% of seats for their community candidates and are entitled to give them preference in admissions as it is necessary to maintain minority status of institutions. Furthermore, in TMA Pi Foundation versus the State of Karnataka, year 2003, the 11 judge bench of the Supreme Court held that the state governments and the universities cannot regulate the admission policy of unaided educational institutions run by linguistic and religious minorities, but they can specify academic qualifications for students and make rules and regulations for maintaining academic standards. And the same principle applies in appointment of teachers and staff. The Supreme Court held that the management of minority institutions should have freedom in day to day affairs of the institution. For example, in appointment of teaching and non teaching staff and administrative control. The court further observed that a minority educational institution does not lose its minority character simply because it receives aid from the government and but at the same time made it clear that they would have to admit non-minority students whose constitutional rights under Article 29 Clause 2 are not to be infringed. A very great judgment. Furthermore, in PA Inamdar versus the State of Maharashtra, IIA 2005, the Supreme Court observed that private, unaided professional institutions cannot be forced to accept reservation policy of the state as it is violative of Article 30 and 19(1)(g). There is nothing wrong in having centralized entrance test being held for one group of institutions imparting similar education. The Supreme Court further held that charging capitation fee is not permitted and every institution is free to devise its own fee structure but subject to non-profiteering. In Bal Patil versus Union of India, year 2005, the Supreme Court held that identification of a community as minority has to be done on a state basis and not all on India basis. The central government must consider the social, cultural, and religious conditions of a community while granting it the status of minority community. It was further held by the Supreme Court that the Jain community is not a minority in the state of Maharashtra. In Chandana Das versus State of West Bengal 2020, the three-judge bench comprising Justice R.F. Nariman, R. Subhash Reddy, and Suryakant of the Supreme Court held that the fundamental rights of minority under Article 30 of the Constitution of India to administer educational institutions cannot be waived. In S.K. Mohammed Rafiq versus Managing Committee, Kontai Rahmania, High Madras, Madarsa, and others, 2020, a judge bench comprising of Justice Arun Mishra and UU Lalit of the Supreme Court upheld the constitutionality of West Bengal Madarsa Services Commission Act 2008, observing that there is no absolute and unqualified right of appointment for minority education institutions. The court also noticed that the statutory provisions seek to achieve excellence in education and also seek to promote the interest of minority institutions. Furthermore, lastly, in Christian Medical College Welfare Association, Union of India and others versus Union of India and others, AIR 2020, the Supreme Court upheld the validity of National Eligibility Cum Entrance Test (NEET) for admissions to medical and dental courses. Bench of Justice Arun Mishra, Finish Saran, and M.R. Shah further stated that the right conferred on religious and linguistic minorities to administer educational institutions of their choice is not an absolute right and it is not free from regulation of state. So the Supreme Court upheld the validity of NEET exam in the case of Christian Medical College Welfare Association versus Union of India. Thank you.